Imagine spending years creating a film, shaping the story, directing the interviews, building the creative vision, only to watch it premiere internationally with someone else effectively presented as the main creator. That is exactly what happened in a recent federal court case here in Australia, McCallum and Projector Films Proprietary Limited, and it has become one of the most important moral rights decisions we've seen in years. Because this case reminds us of something many businesses and creatives overlook. Copyright is not just about ownership. It is also about recognition, reputation, and attribution. And importantly, you cannot simply contract your way out of moral rights with a blanket waiver clause. So, today we are unpacking copyright and moral rights in Australia, what they actually protect, and what this recent case means for filmmakers, designers, writers, photographers, agencies, and creative businesses generally. Welcome back to Elise Explains IP, the podcast where we make intellectual property practical and understandable for business owners, creatives, and professionals. I'm Elise Steegstra. I'm a commercial lawyer and advisor, and today we are talking about one of the least understood parts of Australian copyright law, moral rights. We've recently had a couple of conversations about copyright generally, but this one is a real specific part. Most people understand the idea of copyright ownership, but if you like a recap, go back and listen to the last 2 episodes. Broadly, it's about who owns the work, who can license it, and who can exploit it commercially. But moral rights are different. They are personal rights connected to the creator themselves. And as this recent federal court decision shows, they can become incredibly important when relationships break down, projects become commercially successful, or creative credit becomes disputed. Let's start with the basics. Under the Copyright Act 1968, Commonwealth, creators in Australia can have 3 key moral rights. Number 1 is the right of attribution. This is the right to be properly credited as the creator. If you wrote the book, directed the film, took the photograph, or created the artwork, you generally have the right to be identified as the creator. Number 2 is the right against false attribution. This protects against someone else being credited for your work. So it's not just about your name being omitted. This is also about the wrong person being identified as the creator. Number 3 is the right of integrity. This sounds a bit complicated, but this protects the creators against derogatory treatment of their work, which can involve distortion, mutilation, or alteration that harms the creator's honour or reputation. Importantly, moral rights are separate from copyright ownership, and that distinction matters enormously. You might assign copyright in a work to a company or a client, but still retain the moral rights personally. And this is where businesses often get caught out, because many contracts assume that if copyright is assigned, the creator has effectively lost all connection to the work. And that is not how Australian law operates. For many businesses, moral rights can sound theoretical, but in practice, they often become disputes about professional reputation, creative recognition, industry credibility, career advancement, public perception, and, potentially, future opportunities. For creatives especially, attribution is currency. A filmmaker's credits matter. A designer's portfolio matters. A photographer's byline matters. An architect's reputation matters. Creative industries are heavily relationship-driven. So when somebody is erased from a project, or someone else is elevated as the creator, the damage can extend far beyond just money. And that is exactly why the McCallum case became so significant. So what is the McCallum and Projector Films case about? The case involved a documentary film called Never Get Busted. Stephen McCallum was engaged to direct the documentary. The production company was Projector Films, and another individual involved in the project, David No, was credited in ways that suggested he was effectively the principal director. The dispute escalated after screenings at major film festivals, including Sundance and the Melbourne International Film Festival. You're going to ask a question about what the difference between a principal director and a regular director is? We'll get into it. McCallum argued that he was the true principal director and that his moral rights had been infringed because he was not properly credited and another person was effectively presented as the principal director instead. The federal court ultimately agreed with him. Justice Sharif found that McCallum was the sole principal director for the purposes of the Copyright Act. The court held that there had been breaches of moral rights, false attribution, a breach of contract, and misleading and deceptive conduct under the Australian consumer law. But perhaps the most important aspect of the case was what the court said about the moral rights waivers. The production agreement contained a clause that attempted to broadly waive moral rights. This is extremely common. Many standard creative contracts contain language saying things like, the creator waives all moral rights, the creator consents to all acts or omissions, or the creator will not enforce moral rights. Businesses often assume that these clauses solve the issues completely. But the court said that this was not so in reality. The court held that Australian copyright law does not support a broad blanket waiver of moral rights. Instead, any consent to conduct that might otherwise infringe moral rights needs to be specific, informed, and directed towards identifiable conduct. And that is a very significant finding, because it potentially undermines countless standard form agreements used across film, photography, advertising, publishing, design, software, marketing, and agency work. Think about just about any employment contract you may have signed in the past few years. It probably had a moral rights waiver, and that's probably worthless now. Many businesses have relied on broad moral rights waivers clauses for years without really questioning whether they would stand up in court. Now, we have clear judicial commentary suggesting many of them may not. For creatives, this case is incredibly important. It reinforces that attribution matters. Your role cannot simply be rewritten because a project becomes commercially valuable or politically complicated. And importantly, this case demonstrates that courts are willing to protect reputational and attribution interests, not just economic ownership. For creatives, there are some very practical lessons here. First, read the moral rights clauses carefully. Do not assume that they are harmless boilerplate. Understand what you are consenting to, what alterations may occur to your work, how attribution will work, and whether your credit can be removed or changed. Secondly, document the creative roles clearly. One of the major disputes in McCallum was who was actually the principal director. This is where it gets interesting because you have directors and principal directors, and that credit matters to people in those industries. Creative projects are collaborative by nature, and titles can become blurry very quickly. If the roles matter commercially or professionally, define them properly in writing early. Thirdly, understand what ownership and attribution are different things. Even if a client owns the copyright, creators may still retain important moral rights protections. And that distinction is often misunderstood by both sides. What does this mean for businesses and agencies? In this case, it is also a warning sign for businesses, particularly production companies, marketing agencies, creative studios, publishers, software businesses, and content-heavy organisations. If your agreements rely on broad moral rights waivers, now is the time to revisit them, because the safer approach is moving towards targeted consents, specific permitted modifications, clear attribution arrangements, and carefully drafted approval mechanisms. In other words, specificity matters. The broader and more generic the clause is, the greater the risk that it may not work as intended. And beyond the legal risk, there is also the commercial risk and relationships at issue here. Creative disputes often become reputational disputes very quickly. The fallout can affect investor confidence, partnerships, media attention, recruitment, and industry relationships. So handling attribution properly is not just a legal exercise, it is part of good commercial governance. Although this was a film industry dispute, the implications are much broader. Think about any kind of ghost-written content, heavily edited design work, AI-assisted creative projects, white-labelled materials, website redesigns, rebranded creative assets, social media campaigns, architectural modifications. or software UI changes. Questions around attribution, modification, and creative recognition are becoming more common, not less. And as collaborative and digital creation increases, moral rights are likely to become more commercially important, particularly where personal branding and creator identity drive the value. The McCallum and Projector films decisions are an important reminder that intellectual property law is not only about commercial ownership. Sometimes it is about something much more personal: recognition. Who gets credited, who gets erased, and who gets remembered as the creator. And Australian law does protect those interests. For businesses, the lesson is to stop treating moral right clauses as generic boilerplate. For creatives, the lesson is to understand that your rights do not necessarily disappear simply because someone else owns the copyright. And for everyone involved in creative industries, this case reinforces the importance of clarity, documentation, and proper attribution from the very beginning of a project. If you are dealing with copyright ownership issues, creative contracts, licensing arrangements, or moral rights concerns in your business, and you'd like to have a chat about it, you can book a strategy call through my website at www.elisesteekstra.com. And if you found this episode helpful, please share it with a creative friend, business owner, or agency team member, because these issues affect far more businesses than people realise. Thanks for spending time with me on Elise Explains IP. If you picked up something useful, hit follow, subscribe, leave us a review, or send it to a founder friend who could use this information. And remember, this is general information, not legal advice. If you do want help with your IP, you can book a strategy call with me at any time via my website. The link's in the description. So until next time, own your own ideas.